1968 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်189 MAUNG KHIN Appellant vs the Union of Burma Respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Criminal Appeal Before ဦးကျော်စန်းဦး Judge MAUNG KHIN Appellant vs the Union of Burma Respondent Penal Code Section 396 Statements made to the investigating officer whether admissible in evidence or identification, chance of error in identification, use of statement made to the police by the trial judge, whether compliance or Section 126 CPC necessary. Hell, statements made to the investigating police officer in the course of the investigation should not have been allowed to be given by him while under cross-examination as they are not admissible in evidence. Hell further, evidence of identification based on personal impression should be approached with considerable caution, especially where much depends upon such evidence. A witness may be an honest witness, but the testimony of senses cannot be implicitly relied upon even when the veracity of the witness is above all suspicion. Chances of error in identification are based upon a momentary glimpse in the confusion and excitement of the moment at night, even though there is a gas lamp burning. Hell further, the trial judge freely made use of the statement made by the witness to the police in the course of investigation of a crime privately without paying any regard to the law and procedure. He should not have referred to this statement at all without complying with the requirements of the provisions of Section 162 of the Criminal Procedure Code to the prejudice of the defense as well as the prosecution. MAUNG KHIN and others ILR 13 Run 1 Maung Lon Tao ILR 13 Run 517 FB Chilai Thong Wei Teng Aung and 19 others versus the Union of Burma 1958 BLR 582 AC Doklima versus the Union of Burma 1962 BLR 280 CC B Yansu A Maung Tao Nyon versus the Union of Burma 1966 BLR 43 referred to Utangwe for the appellant, Unit government advocate for the respondent. U Judge. This is an appeal against the conviction under Section 396 of the Penal Code and the sentence of transportation for life. The most important witness for the prosecution is MAUNG. Plaintiff Witness 2, the wife of the deceased Ko Tan Nyon, who was shot by the dacoits from the back on the night of 17 December 1961 in Ong Pin Village, Chabong District. At the time of the occurrence, U Po Nyan, U Cheng and his wife, Do Tang, Matin, the younger sister of MAUNG. Plaintiff witness 3, 4, 5, 6, and 13 were in the house of the deceased with the exhibit air pressure gas lamp burning in the room. The list shows its mantle and 2 glass strips of the chimney were broken while another strip was missing. According to MAUNG, her father, U Sanpe, plaintiff witness 1, called Matin, plaintiff witness 6, from the back of the house and asked her to open the door. When the door was opened, MAUNG and her sister Matin looked out and a voice was heard to send down the deceased. When U Sanpe was brought up, MAUNG followed her husband and she saw 3 men who asked her not to come along. They tied up her husband, deceased, and she was sent back upstairs. 3 men came up bringing the deceased blindfolded and made all the inmates prostrate before one of them, armed with the rifle, asked MAUNG to come forward and surrender what she had. The other 2 men were armed with darts. She took out the cash and the jewelry from under the mattress and handed them over to Mountain Law, the co-accused, who was somehow acquitted. The trial judge said in his judgment that MAUNG might have accused Mountain Law by mistake. MAUNG deposed that she knew this man for the last 5 years as he lived in Pyabong, and some years ago, one day he came to have breakfast in her house, and yet the court thought fit not to convict him. One of the 2 men with darts was the present appellant, whom she said she knew for the last 6 years, but she did not know in which village he lived. After the cash and jewelry had been handed over to Mountain Law, 2 more men came up, and one of them was Seymour, whom she handed over the key as told by her husband, the deceased. As Seymour said he could not open the box, she herself opened the box and gave some more jewelry and cash to him, Seymour, and yet this Seymour was never made an accused in the case. U Thong Myeai, plaintiff witness 11, the investigating police officer, under suspicion, gave no explanation. In his cross-examination, the court should not have allowed to give the statements made to him in the course of the investigation, as they are not admissible in evidence. MAUNG stated that one of the losers then let off the pressure from the gas lamp, but the police got the light from a kerosene lamp. About 20 minutes after the man had left, a sound of firing was heard. MAUNG found 20,050 jets, 2 radios, 1 belonging to U Sanpe, gold comb, gold body strap, bracelet, gold chains, bangles, brooch, watch, and gold strap, stud, rings, gold buttons, earrings, men longies, ladies longi, and other properties missing from the house. She deposed that she told U Chen and his wife, Do Tang, plaintiff witness 4 and 5, that the appellant MAUNG Mountain La and Saint Maung were among the Luzon. She said she learned that very night that her husband was shot dead. According to Usambe, 7 men came to his free hut and forced him to take them to the house of the deceased. He said he asked his younger daughter, Maddie, plaintiff witness 13, to open the back door. No reference whatsoever was made to Maddie by him. When the door was opened, Maddie and Mawin looked out and one of the Luzos said he wanted to meet the deceased. When the deceased came out, the witness was taken upstairs by 3 men, 1 armed with a rifle and 2 with darts. One of the inmates were lying on their stomach, as ordered by the Luzo, who had smashed the gas lamp. The witness, Usambe, had the Luzo asking to produce the properties, and when he took a quiet look at them, he saw the deceased with his hand tied, being led away downstairs. He said about 10 minutes after the Luzo had left, he had the sound of firing twice. According to him, the Luzo searched with the aid of their electric torches. The trial court did not believe the story. If the lamp was really smashed, the police would not have produced the exhibit gas lamp in the condition it was produced before the court, and Mawin could not have identified it in court. None of the other witnesses corroborated him. He lost his radio and other properties. He did not recognize any of the Luzo, and none of the inmates ever told him anything about them. So far as the recognition of the appellant is concerned, Usambe evidence is no help to the prosecution. Uponyan evidence showed that when he was lying on his stomach, one of the 2 Luzo, who were making a sash stamp his back about 8 times with his heel and struck him with the blade of the dart, twice making him look at when he saw the appellant. He said when the Luzo were about to leave the house, the gas lamp went out. According to this witness, there was no other lamp and the place was in complete darkness. He contradicted the evidence of Melvin. The witness admitted in his cross-examination that he was in great fear and had only a momentary glimpse of the appellant when he was stabbed and struck by the Luzo. In this circumstance, I doubt very much his recognition of the appellant. To use his own words, ထို့သောလမ်းကြည့်ကြည့်ခြင်းမှာကြည့်လဲကြည့်မြင်လဲမြင်မှောက်လဲမှောက်ဖြစ်ပါသည် Evidence of identification based on personal impression should be approached with considerable caution, especially where much depends upon such evidence. A witness may be an honest witness, but the testimony of sense cannot be implicitly relied upon, even when the veracity of the witness is above all suspicion. Chances of error in identification are based upon a momentary glimpse in the confusion and excitement of the moment at night, even though there is a gas lamp burning. According to Upo Chain and his wife, Plaintiff witness 4 and 5, the Luso made them all prostrate as soon as they came at, and the former stated that he was so afraid that he dared not look up. And when they were about to go away, one of them made him get up and took away his fountain pen and made him prostrate again. He said he did not remember even this Luso, in spite of the fact that the gas lamp was then still alight. The most important part of his evidence is that MAUNG told all the inmates there rather loudly that she recognized the appellant MAUNG and MAUNG. He did not mention the name of Saint MAUNG, whom MAUNG said she mentioned. It is strange why he did not make any mention of Saint MAUNG, whom MAUNG knew very well and who took a leading part in the daguerreotype. CHIN said Sanpe was then near him and he and others could have had what MAUNG said, but no one stated that she had. MAUNG said that she recognized the appellant and MAUNG. CHIN admitted that he did not state to the police what MAUNG said. I do not think this witness can be believed. He said in his cross-examination he knew the appellant for the last 2 years, and he had seen him casually when he was doing cultivation, but when he was recalled, he stated that he had never seen the appellant and MAUNG before. His wife, daughter, stated that they lit the lamp after the Luso had left. She could not say how many of them came up, as she did not see them. One of them had taken about 13 from her pocket. She only had MAUNG say that she recognized the appellant and MAUNG, accused who was acquitted. She said she had this before she had the sound of firing, but according to her husband, MAUNG told them after the firing. According to her, all the inmates mentioned above were around her when MAUNG said she recognized the appellant and MAUNG, but it is rather strange that only she and her husband had what MAUNG said. Plaintiff witnesses stated that she and Madden opened the back door, but she was contradicted by Sanpe, as pointed out above. The less important witness for the prosecution is Madden, plaintiff witness 13, the younger sister of MAUNG, but the trial court disbelieved and rejected her evidence on the ground that she exaggerated very much. She said she opened the back door with Madden and that she was not allowed to prostrate, so she saw the appellant as one of the two who came up armed with darts. When everyone had to prostrate in the light, it is unbelievable that she alone was excluded. In a very serious case of this nature, involving death sentence, the prosecution must prove its case to the hilt. If it relies upon the evidence of an alleged eyewitness, that evidence must be foolproof and well corroborated. In the instant case, I have shown above that the evidence of MAUNG is not reliable as she is not corroborated in all the material particulars. When she could make a mistake in identifying Mountain La, the co-accused who was acquitted, as the trial court had said in its judgment, she could have made a similar mistake in identifying the appellant under the same circumstance. Not a single property was recovered from the appellant. MAUNG deposed that the piece of cloth that covered the face of the dead body was from the appellant Longi, which he wore 2 months before the occurrence at the funeral. This sounds very preposterous, and the trial court, I think, rightly rejected this piece of evidence when MAUNG said that she recognized Seymour and gave a detailed account of the part he played in the commission of the crime. The trial court did not believe her and said in its judgment that she was exaggerating. In these circumstances and in the circumstance narrated above, it is impossible to rely upon her evidence on which the case against the appellant stands. The appellant cited an alibi as his defense. He said MAUNG had a grudge against him as his dog made use of her small crib. He deposed he was ill with his sore on the leg since 3 days before the occurrence, and on the night of the occurrence, he sent Koboga, defendant witness 3, to call the shampoo man, Aung, defendant witness 2, to shampoo him. He said Aung was shampooing him that night from 6 p.m. to 9 p.m. Koboga and Aung supported him, but the trial court found some discrepancy in their evidence. For example, the question whether the appellant was asleep or not when the sound of firing was heard, whether the appellant slept inside the mosquito curtain or not, etc. Be that as it may, in a criminal case, it is needless to point out that no duty is cast upon the defense to put out a negative proof of the guilt unless it claims some sort of exception. The presumption of a prisoner innocent is the first principle of our criminal law, a golden thread that is always expected to be seen throughout the work of our administration of criminal justice. So far as MAUNG evidence is concerned, the identification made by her at night during an occurrence, such as the Guadi, when blows were struck and the people terrorized, is generally of very little value. Before I conclude, I think I should say a few words about the use of police statements made by witnesses in the course of investigation of a crime. In the instant case, the trial judge freely used these statements privately without paying any regard to the law and procedure. In the first place, he should not have referred to these statements at all without complying with the requirements of the provisions of Section 162 of the Criminal Procedure Code to the prejudice of the defense as well as the prosecution. The trial judge would be well advised if he refreshed his mind by reading the case of KHIN and others 1, the case of Ngalon Tang 2, the case of Chit Lai Thong Wei, Teng Aung and 19 others versus the Union of Burma 3, Dokalima versus the Union of Burma 4, and Piyanso A. MAUNG versus the Union of Burma 5, and the relevant authorities rely upon in these well-known decisions. Section 162 of the Code of Criminal Procedure prohibits the use of these statements as provided in that section. In the case of Ngasu 6, which was an unreported case referred to in Ngalon case, 2. Bagule J made a attempt. The judge would be well advised to refer to police paper privately. This dictum was dissented from in this full bench decision of Ngalon 2. It was held by the full bench that this dictum goes too far. The law laid down in the case of Ngau Khai and others 1 was confirmed by the full bench. Statements of witnesses in the police paper ought not to be treated as evidence in the case. In suitable cases, the court should use its discretion and inform the accused of his right under Section 162 and point out when required material passage in statements made to the police. It would be best if the court does not interfere but keep its position as an impartial arbiter between the state and the accused. If the accused is undefended or the case is in the hands of an inexperienced lawyer or court prosecuting inspector of police or inexperienced judge or magistrate, it is best to make it clear that the court has the right to take the initiative in suggesting to the defense that the use of the powers given to the accused under Section 162 might very possibly be of benefit to it. And once the accused accepts this suggestion, the court can then give him a copy of the police statement. In the case of Ngau Khai and others 1, it was pointed out that a judge or magistrate has no authority to look at the police paper unless requested to do so by the accused. The purpose for which the court refers to the statement is to see whether any part of the statement ought to be excluded under the second proviso to Section 162 of the Code of Criminal Procedure, and not for the purpose of deciding whether there is material for cross-examination under Section 145 of the Evidence Act. It is not for the court to decide whether there is any variation between the statement made in the examination in chief and the statement recorded by the police in Chilai, Thong Wai, Teng Aung, Pa 22 ဦးနှင့် ပြည်ထောင်စုမြန်မာနိုင်ငံတော် 3. It is laid down သက်သေ၏ရဲအရာရှိရှေ့အစစ်ခံချက်သည်အမှုစစ်ဆေးသောရုံးတော်ကအမှုတွင်ထည့်သွင်းစဉ်းစားနိုင်သောသက်သေအစစ်ခံချက်မဟုတ်ထိုသက်သေ၏အစစ်ခံချက်ကိုယုံကြည်ထိုက်မယုံကြည်ထိုက်သို့တည်းမဟုတ်တန်ဖိုးမြည်၍မြည်မျှရှိသည်ကိုချိန်ဆနိုင်ရသာဖြစ်သည် In this appeal, no reference whatsoever was made to the police statement as it might prejudice either the prosecution or the defense. These statements have been entirely ignored, as without them, there is no difficulty in the disposal of the case. For all the reasons given above the conviction and sentence are set aside, and the appellant is directed to be acquitted forthwith so far as this case is concerned.